Hi, I'm Steve Dans. I want to thank you for coming to visit our YouTube video on employment law. And today we're going to talk very briefly about an overview of what you should do when you sense, and I suspect that's why some of you are watching, that your employment may be involuntarily terminating. We are in California. We have offices throughout California. We have represented employees against the largest employers in California, against some moderate and small-sized employers. But the basic rules of how to litigate, prepare for litigation in an employment context are always the same. So we're going to be talking today about the difference between what you should do to help yourself while you're still employed. Then for those of you watching who have already left employment, we'll talk a little bit about what to do. So here are the steps that we want to talk about today. If you're still employed by a California corporation, you want to make sure that you have gotten documents that you may need to prove your case down the road. That could be copies of your personnel file, any write-ups that you've received, a list of documents, for example, that might suggest where there was some complaints that you had against the company, possibly for discrimination or illegal behavior. So it's very important to document as specifically as you can while you're still employed. We never tell our employees to take documents and never to take originals, but if you have something that indicates, for example, the date, time, place, recipients of an email, that would be very important in documenting your case. Similarly, you can write a confirming email if you're given an oral instruction while you're still working that you don't believe quite sounds right, and you can question it in writing politely, and that would help prove that you did complain about what the company refused or neglected to put in writing. Still employed, consider what we call our Sad Valley letter. That basically is telling the employer you love your job, you hope to work there for the rest of your career, but unfortunately there may have been a speed bump or two created, and you need to get past that. You then would go on in polite and respectful language to explain the problem and a reasonable resolution of the problem. Many employees get in trouble on that letter because their demand is not legal or reasonable in the eyes of the law. So we'd like to help draft Sad Valley letters. Let us know if you're in that situation, still employed. Curtain now closes, comes open. We talk about after employment. Let's say you're watching this video now for the first time since you've been involuntarily separated. Assume you have not signed a severance agreement. If you have, you may only have 7 days to revoke your signature, and that's usually only for folks over the age of 40, and that's usually only for the age claim. So we hope that you have not signed a severance agreement without carefully considering it, but in the event that you are ready to sue or look into it, you'll want an attorney who will issue a litigation hold letter. That basically tells the company to preserve at their peril any and all documents having to do with your employment and any other issues that you list on that litigation hold letter. That can be a shot across the bow to many employers. They will take it very seriously. They must in turn tell their employees to honor this litigation hold request. So it's a very powerful tool, has to be played very carefully, can set up your entire case for a good settlement. You also would like to get documents. You're entitled to 3 categories of documents under the California Labor Code automatically, and a document request would seek those documents. Essentially your personnel file, any writings you've signed, and your payroll records. So you want to get documents. Those are required to be given to you no more than a month out. In some cases, you may have to file an administrative claim. There are short time periods with that, so you should immediately file whatever administrative claim is appropriate. Usually it's a claim with the Labor Commissioner, with the Labor Workforce Development Agency, or in the majority of cases with the State of California Department of Fair Employment and Housing. There is also the possibility of filing with the EEOC, the Federal Equal Employment Opportunity Commission, but we believe that employee rights are better protected under the California Fair Employment and Housing Law. There are ways to cross-file, so that's a complicated subject, but If you're going to go only to the EEOC, be aware that you only have 300 days versus 1 year from the last act of like-kind discrimination if you go to the state agency. Finally, once all these steps are taken care of, you have to consider whether a lawsuit is in your best interest, whether you've signed an arbitration agreement, whether a mediation proposal directly to the company would be the best and quickest way to go. So we're going to look at all of these from your standpoint, what's best for you. Good employment lawyers have many arrows in their quiver, and they should be ready to pull them as appropriate to your case. As always, this is not legal advice, educational in nature only, but we hope you will contact us at Stephen Dans and Associates if you're California based. Thank you so much.